And the last cause of vitiating consent is mistake. What is mistake? It's a false belief of something. Like you see a diamond, you think it is a diamond, but it's not. It's just a mere glass, no, being shined. So what are the requisites of mistake? Or 5. So it refers to the object of the contract. It refers to the nature of the contract, to the principal conditions in an agreement, or if it is the main reason of giving or the consideration of the contract, the error as to person. Let's say you are donating a property to a person who you thought is your father, but then you discovered he's not your father. Yeah. Or error as to the legal effect. So when mistake is mutual and frustrates the real intention of the parties. So this is mutual mistake. So both parties are committing mistake. So when a person enters the contract by mistake, so that contract is voidable. No? Okay. So we go now to the form of contracts. What is form? Form is in some kind of contracts, because generally contracts are consensual, meaning they are perfected by mere consent or mere agreement. So there is no absolute form required by law. What is a form? It is the paper, no? The form. So form is a manner in which a contract is executed or manifested. So that's the form. So the first kind of contract, informal. So only giving him consent, object and cause. There's no form. Like if you are going to take a taxi and you want to be transported to SM Seaside, there's no formal requirement. So that kind of contract with you and the driver of the taxi cab is called informal contract. Well, there are formal contracts. So in here, it is required by law that it should be in a specified form. There should be a form. So example of this is donation of real property. So in donation, there should be a form. So if somebody will give you a real property and without any deed or paper, deed of donation, then that donation is not valid. No? Number 2, stipulation to pay interest. So if there's a loan and there's an interest charged to the loan, so it should be in writing. Transfer of large cattle. So large cattle is being transferred to another land. It should be in writing. Sale of land through an agent. So if you are going to be an agent and you're selling the land of another person, so it must also be in writing. Otherwise, you cannot claim commission if the transaction was, even though the transaction was successful. No? So an agency must be in writing. Contract of anticrisis should also be in writing. This should be I already discussed this one when you loan and the contract, the accessory contract is a parcel of land to secure the loan, and payment of interest will be covered by the crops or harvest of the land. No? So they can buy the interest because any harvest or crops being harvested from the land will take care of the interest. So it should be in writing. Another contract should be in written. It's a contract of partnership. Registration of chattel mortgage. Chattel means personal properties. If it is being mortgaged, it should be in writing. Donation of personal property in excess of 5,000 pesos. Personal property meaning movable property. Huh? So it should be in writing. This kind of contracts. Donation of real property, stipulation to pay interest, transfer of large cattle, sale of land through agent, contract of anti-crisis, contract of partnership, registration of chattel mortgage, donation of personal property in excess of 5,000 pesos. So the third kind of form is real. If it is involves the creation of real rights over immovable property, so it must be written. No? You know what are real rights? I have defined that in the previous video. So when is form important? For validity, informal and solemn contracts, for enforceability, in statute of frauds, and for convenience. You will know what are statute of frauds in the next video. The other hand, there is what you call public instrument. So there are contracts which must appear in a public instrument. So when do you say that a contract or a deed or document is a public instrument? This happens when the document has been acknowledged by a notary public, meaning there is a notarial act. In our Visayan language, na ay notaryo. Okay? So that makes an instrument public. So these are the contracts which must appear in public instrument. Creation, transfer, extinguishment of real rights over real property, like sale, repudiation or renunciation, another word, waiver, of hereditary rights. So, di ka mo inherit, waive ka. Or of conjugal partnership of gains. So you will not get your share. Let's say nagbuwag ang husband and wife. The husband will not get his share. So it must be in writing. Or it must be in a public instrument. Another special power to administer property of another person. So it must appear in public instrument. And cession, the same word as repudiation or renunciation. Cession, waiver of actions or rights proceeding from an act appearing in a public instrument. So these four must appear in public instrument. So if there's a question, what are the contracts which must appear in public instrument? So these are the answers. Let's go to the last topic, which is reformation of contracts. Reformation is a remedy to conform to the real intention of parties due to mistake, fraud, inequitable conduct, or accident. This prescribes in 10 years from date of execution of contract. Prescribes meaning expires. So if after 10 years from the date of execution, you can no longer have this remedy to reform the contract. So what's the reason? Because the real intention of the parties is not in the contract because of mistake, because of fraud, because of inequitable conduct or accident. So these are the causes or grounds. Mutual, meaning the instrument includes something which should not be there, or you should erase or omit what is there. Then unilateral, meaning one party was mistaken with the other party, either acted fraudulently or inequitably, or knew about the fact but concealed it, so did not tell the other party. that there is something wrong. So in this case, the party in good faith may ask for a reformation. So there's no cancellation of the contract, but only reformation. I-reform lang. Number 3, mistake by third persons due to ignorance, lack of skill, negligence, bad faith of drafter or clerk or the typist. So maybe the typist or the clerk, or because of ignorance or lack of skill or bad faith, made a different document instead of contract of sale. She made a contract of lease, no? Imbis baligya, ipaabangan na lang noon. So in that case, that is mistake by a third person. So the remedy is to reform. Then other specified by law, which have frustrated the true intent of the parties. So here we have requisites that there is a written instrument and there is meeting of the minds between the parties, and their true intention is not expressed in the instrument or the document. No? So there is clear and convincing proof and facts put in issue in pleadings, meaning there is already a case filed in court. So reformation is not applicable to simple donation inter vivos. What is simple donation inter vivos? Meaning donation while still alive, or wills, or void agreement. No? If the agreement is void, it cannot be reformed. Or estoppel when the party has brought suit to enforce it. Okay, so this ends part 2 of contracts. For any questions or clarifications, you may send your questions to my Gmail account or through my FB, Attorney Lyndon Mac. Have a good day.